in order for something to be a preference, it has to satisfy the requirements that are found in Section 547B of the Bankruptcy Code. So if you're watching this interview, watching this video, and you're at all curious, you can look that up on the internet. So there are several elements. First, the transfer was made to or for the benefit of a creditor, someone to whom the debtor owes money. So if it's a transfer to somebody who isn't a creditor, it doesn't fall within the context of a preference. Now, it may be something called a fraudulent transfer, about which perhaps we'll speak in some future interview, but at least within the context of a preference, the transfer has to be done to a creditor. And the transfer has to be made to make a payment on an antecedent debt, a debt that the debtor owed prior to when the transfer was made. So if the transfer took place before there was any debt, then it's not a preference. Next, the transfer has to have been made while the debtor was insolvent. And now, what does insolvency mean? Well, there are a couple of definitions that are used in bankruptcy. The most common is we take the sum of all of the liabilities that the debtor has, and we compare that number to the sum of the values of all of the assets of the debtor. And if the debts exceed assets, the debtor is insolvent. Now, there is another definition that sometimes comes up. It's a little bit different, because you could have a debtor who, if you added up all the assets and added up all the debts, or it looks like the debtor is insolvent, that is, the debts exceed the assets, but the debtor can make the payments on whatever liabilities they are, the debtor has, as they come due. So another definition that comes up, the debtor isn't making payments on the debts as they come due. Because the debtor could have a pretty steady stream of income, and taking a snapshot, if you add up the value of the assets, they're less than the sum of the debts, but the income is enough coming in at any given time to service the debt. In any event, that's the next one. The debtor has to have been insolvent at the time of the transfer, and there is a presumption, at least in the Chapter 7 case, that the debtor was insolvent during the 90-day pre-petition window. That is the window of time prior to when the debtor files the bankruptcy petition. And then I've already mentioned earlier in our discussion, the transfer was made within the 90-day period prior to filing the bankruptcy petition, or if it is an insider, that gets extended to a year. And the transfer enables the given creditor to receive more than it would have received if the case were a Chapter 7 liquidation case. So those are really the elements of a preference. And so the trustee seeking to avoid that preference has to show to the court's satisfaction that all of those elements are satisfied. And if they are, then the judge will enter an order avoiding the preference.